Okay, hopefully this works this time. I've been interrupted 2 or 3 times. And so we're going to do part 3 of my case. The IRS steals my home. This part has to deal with the summary judgment portion of the process. And it'll be like 6 parts because we're going to have the government's summary judgment motion, my summary judgment motion, the oppositions to the 2 motions, and then replies thereof. And just so you, for the lay people, summary judgment motion is where they try to dispense of the case without having a trial by jury. And a summary judgment is usually based on the idea that there's no dispute on the facts, that it's only a matter of law to decide the case, because based on the idea that both parties agree to the facts. Of course, that's not the case in this case, but that's what the judge says. So the judge says, oh, we only have a technical disagreement here, but the facts, both parties agree on the facts, so this is how to take your jury trial away from you, okay? So on the summary judgment points and authorities from the government, the introduction says the United States motion seeks to reduce the judgment and federal tax liability of Michael Benoit, the judgment and foreclosure of the related federal tax liens. Now they start off with a statement of facts, which are interesting because, you know, the sun is hot is the statement of facts. I don't know what it has to do with the case, my case. During tax year 95, Benoit worked at the building inspector, provided consultation services, and during tax year 1995-96, Benoit was the president, and that I had 10,000 shares. I don't understand what that has to do with having any taxable income or taxable liability. And the idea that I worked there doesn't mean I got compensated. Benoit was compensated for his work. Now, that's, if you look at the evidence, and you're not going to see it here, during the interrogatories, they showed checks, and the checks were made out payable to me, and somehow they concluded that that was compensation for work, which they have no way of knowing whether or not those checks were repayment of loans I made to the company. They just assumed they were compensation. So, and then they say that I received compensation from distribution of flyers. Well, in that same year, 95 and 96, the actual testimony is, and they don't have any other record other than my testimony, is that I don't believe that the flyer service existed in 95, 96. But that doesn't matter with the government. So Benoit had living expenses that he paid with the money he received from working at the building inspector. This is not a fact. This is an opinion. They have no way to tie that I paid my expenses from money that I received from working at the building inspector. That was not my testimony. It's not. And then they pointed to the depositions, and we can go into that, but no need. That I did not file IRS Form 1040 for 95, and did not file IRS 1040 for 96. And of course, yeah, that's true. I did not. I didn't have any taxable income, so you don't file those forms if you don't have taxable income. Benoit received IRS letter 531 notice of deficiency. Yeah, okay, so yeah, I did receive that, but did I receive it according to the regulations and whatnot? You'll find out later that I didn't. So these are their statement of facts. And then on the dates and in the amounts and for the tax period set below, a duly authorized delegate of the Secretary of the Treasury made assessments. So they're making a statement that this is facts, that someone made assessments on these dates. But when I asked for that in discovery, they couldn't produce any assessments, as you remember. So, and I'm not going to go into the details of all of that. Skip a little bit here. Now they start the argument with that the issues presented, whether Michael Benoit is indebted to the United States in the amount of $144,847.44 as of December 29th, 2009. So that's an issue, and whether I'm indebted for that amount would, because it includes interest and penalties and et cetera, et cetera, et cetera. The question is whether I'm indebted for that whole amount, that exact amount. Whether the United States is entitled to foreclose the related federal tax liens on the parcel of real property identified in the complaint. Now, they go into their argument and they explain the summary judgment standard. They say summary judgment is proper if the pleadings, depositions, answers to interrogatories, and admissions on file, together with the affidavits, if any, show that there is no genuine issue as to any material fact, and that the moving party is entitled to a judgment as a matter of law. So the key question there is that there's no genuine issue as to any material fact. Now, in this case, you'll find out there is lots of issues as to material facts, whether or not I had income, whether or not I had taxable income, whether or not these penalties that they applied actually applied to me. And so those are serious issues of material fact. Whether or not I was actually subject to an Internal Revenue Code tax. That's a matter of fact. That's a question of fact. And so that this standard, if there is no issue of material fact, then they just go to law, and you can have, a trial or judgment on based on the law. Now, when you got two civilians and the facts are this, they say, yeah, these are the facts, but I don't owe them any money because the law says this. Then it's natural, just go to the law. But if one of the parties say no, a different set of facts, and it's a genuine issue, whether or not there were assessments is a genuine issue. So they go on and cite the other cases on this. And they say once a movement's party is met by producing evidence which, if uncontroverted, would entitle the movement to judgment as a matter of law, the burden then shifts to the non-moving party to set forth specific facts demonstrating that there is a genuine issue for trial. So later on, you're going to see in my response that I did set out facts that show there is a definite or a genuine issue for trial. And of course, they cite the rules on it, and I actually cite the rules when it comes to my time. And of course, they say conclusory allegations unsupported by specific factual data are insufficient to create a triable issue of fact so as to preclude summary judgment. So one can't just come up with conclusory allegations unsupported by specific factual data. Summary judgment is properly granted against Benoit for his outstanding tax liability. This is what they say. And in an action to collect federal taxes, the United States bears the initial burden of proof. See, Palmer, okay, yeah, that should be true, right? That burden can be satisfied through introduction of proof of tax assessment. Introduction of proof of tax assessment. Now, of course, I was asking for proof of tax assessments all along. And it says that which are entitled to the presumption of correctness, so as long as they are supported by a minimal factual foundation. So through introduction of proof of tax assessment. Okay. Certificates of assessments and payments 4340 are routinely used to prove that assessments have in fact been made. Now, the thing about that is these certificates of assessments and payments, and you'll find in my response that the court case refers to someone having a trial. And if these certificates of assessments and payments are produced at the trial, they're routinely used to prove that assessments in fact have been made, but not for summary judgment process. And that I have evidence disputing that they hadn't been made because it wouldn't produce them for me. All right, and they say they're presumptive self-authenticating proof of a valid assessment. Well, they're highly probative, and the absence of contrary evidence is sufficient to establish that an assessment was properly made and that notices and demands for payments were sent. Well, I do produce contrary evidence that shows that that the assessments weren't properly made. In fact, they can't even show that they were made. So this is just like, putting this form in the doubt. In this case, certificate of assessments and payments for the tax years at issue are attached. Now you find out as you go along in this thing is that there are two different sets of assessments and etc. Payments for tax years. I'd been requesting those since 1997, 98 for copies of these certificates of assessment, and they didn't produce anything until 2006. So these 2006 forms with information on them supposedly are accurate and reflect what happened from 95 on. But they couldn't produce those for me when I asked them earlier. And you'll see that as actually a legal argument that buttresses my point that actually I should have won these things. And they go in there and make misstatements about my deposition. So I'm not going to cover that on this one, but I will cover it when I get to my opposition to the government summary judgment motion. And so, blah, blah, blah. Actually, it'd be more that I rebut the stuff that I talked about on my summary judgment opposition. Right? So they're saying the summary judgment evidence conclusively demonstrates that Michael Benoit is indebted to the United States for tax, interest, and penalties, You'll have to wait to see mine to see that that's not a true statement, my rebuttal. Now, there's another thing that with this evidence that's submitted, and then we'll be going into depth later on this, but the evidence is submitted by a declaration of Carrie D. Larson, person acting as an attorney for the United States. And this declaration is submitted based on not knowledge, which is a requirement of the rule, but it's submitted on information and belief. And this declaration, she's signing it as an attorney, trial attorney for the Department of Justice Tax Division. We will find out later that she's no such thing. And so the rest of this is a bunch of her documentation, and it includes conflicted information. And I'm not going through the deposition and her statement of facts that I could. We could do an hour on that, where she says in her statement of facts something that's different than what I say in my deposition. But she just states it that way in her points of authority, so I guess the legal mind's reading it, assuming that she knows what she's doing, probably don't even bother going to my deposition to see, especially because it's the government judging against the government. So that's the government's motion for summary judgment. Don't you think that when it's the government against the individual, that the summary judgment process should not go into play? Yeah, you can see it with one individual against another individual, and they both agree on the facts, and neither one of them are sitting there saying, no, those aren't the facts, no, I disagree on the facts. And the court doesn't make a decision like, no, both parties agree on the facts and push it forward. When it's the United States going against a citizen, and the United States is sitting on the bench, don't you think that the summary judgment process that denies somebody the right of trial by jury would not be allowed to go forward in such a case? That all the facts would be tried, and again, you only got some of the information the government presented, and yeah, no, I didn't file a tax return, and no, I didn't have taxable income. So, I mean, it's true that I didn't file a tax return. You don't have to file a tax return if you don't have any taxable income. or you don't owe any money. So they dream up this idea that I owe money and that I had income because I received checks. Um, I loaned the building inspector a lot of money. I don't know how much of those checks were from the money I loaned the building inspector at this late date, because it was 95 and 96. That was the company's name, the building inspector. So that'll be all for the broadcast now. Tomorrow we'll pick up my opposition to the government summary judgment motion and go over the things that we're opposing, and show you the cases that actually back up the fact that I have refuted their Form 4340 and rebutted the presumption of correctness given to that form, what should require the courts to proceed to trial. Something I didn't get.